I am a lawyer in central Minnesota, and I am watching the Kyle Rittenhouse trial. I typically do a live show every weekday at 11 p.m. Central Time, 11 p.m. till about 2 a.m., including last night. So it is almost 9 in the morning. I had a nice short night, and we will continue on with Kyle's issues. And on this channel, we will be watching basically all of the trial that is findable, we'll say. I think that's the wording to use here. Findable. All right, so give me your rundown of the case so far. What have you seen? What do you think? Where are you on this issue?
So I share your continuing confusion on the gun possession charge, because the way you've read the law seems right to me. I would consider myself open-minded on the issue, though, because I'm willing to hear a good counter argument, and I really haven't heard one. So I think you're right, but I'm maybe not as sold as you on it ultimately, because it's like maybe there's an argument somewhere I haven't thought of, but none of them so far have made any sense. As to the underlying issues, though, I think the self-defense claim is pretty rock solid. As you pointed out yesterday, the issue is subjective and objective. So we asked two questions. Did Kyle Rittenhouse experience a fear of death or grievous bodily harm? Probably. I mean, he just, in the first shooting, a gun had just gone off and he's being chased. Pretty good. And would a reasonable person in that position feel the same thing? It's like, yes, probably. Yeah. So the self-defense claims look pretty solid to me. Again, waiting to hear any sort of counter argument, because we only have the videos, but so maybe some eyewitness will testify to something that we somehow haven't come to our attention. That would be nice to understand the prosecution's case better. But so far, I think Kyle Rittenhouse is in the clear. Given what we presently know, a judgment of guilty would, in my opinion, not be legally sustainable. It is not legally viable. A reasonable jury, based on what we know, cannot come to the conclusion of guilty.
Yeah, so, I agree with that. No, I got no reason to change your mind. I actually wanted your opinion on a different issue related to what you just said. So let's say we do get a jury who makes that decision. Sure. Do you think, from what you've seen from Bruce Schrader, the Honorable Bruce Schrader so far, that he would be open to a JNOV?
I can't really say. I would say, as a general proposition, I think many judges are very reluctant to a JNOV. So if you had to predict, you'd predict against.
Yeah, I think that's safe. He just seems there is no audio yet.
He's got immerse.
It's not just you guys that it's muted for. It's muted for me too. Yeah. Okay. So JNOV is a judgment notwithstanding of the verdict. It's a way that the judge can basically say, okay, the jury said this, however, like, come on.
So the chat is saying it's 11 women. Is that the right demographics? Do you know?
I have no idea.
Yeah, we can look that up somewhere, I would think. Jury, Kyle Rittenhouse.
It's certainly possible.
Yeah, I mean, anything's possible. Let's see. Seated. Let's see. And they selected 20 people, which I don't quite understand. Oh, okay. So the 20 consists of 11 women and 9 men. So, yeah, we don't know. Are all 9? Yeah, it doesn't say which are alternates and which are not. So it isn't that specific.
An alleged exception, which we are alleging here.
Okay.
And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And
okay, this is on the gun issue
is that
as a minor.
I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week. Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to, I looked at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation of the forfeiture action alone. And I can just tell them I'll instruct them on everything at the end of the case. How do you feel about that?
Judge, I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. It is not the subject for a motion to dismiss. The complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually.
But even if it's an affirmative defense, doesn't the state have to prove it?
They wish.
Yes.
Case, if they wish to raise
And if
an
it's
affirmative
a matter
defense,
of
which is
law,
that, he was
Yeah.
compliant
there's no
under
issue of
both
material
those,
fact in question here.
But I do like that the judge seems to be keeping an open mind on this issue. He didn't just slam him down.
Or the certificate of completion that the
This man is
second
not
part of
good
that,
at wearing suits.
third part of that statute
Nope.
calls for. They can do so.
What's going on with his neck
I don't see
line?
why that should
Yeah.
be in the jury instruction. We don't have the self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly.
What do you mean you don't have self-defense in the jury
That can
instruction?
be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not want to. I did not want to be untimely, but that does lay out why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of,
I think you submitted that brief.
Curfew violation, we're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
I don't think anything's precluding you from having a 12-person jury,
Sever
is
it.
it?
No, sever
Well,
it.
it's different
That'd be
standard of
funny.
proof.
Sever it.
Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause. We've met our standard in the complaint, and it's been bound over. And now it's
Also, just
defense if they want.
I don't like his posture, and I don't.
We disagree that being 17.
Well, also, what's with the sitting?
is
I
raised
don't.
as affirmative defense.
While talking to the court,
Means
that's
you have
weird,
to,
isn't it?
Present the certificate
Yeah.
of completion
He's sitting very strange.
of a hunter safety permit as called for in the statute. Thank you.
Well, okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those.
Yeah, I'm not sure why you would give any jury instructions at the start necessarily.
Well, I don't know if and that's probably not the best thing.
Other than, the standard instructions
Then
of
what
you
we're
can't
talking
talk about the case,
Um,
that kind of stuff. But why you would give
well,
legal instructions as to
what's your
law
reaction to the claim that it's an affirmative defense?
seems
Not an affirmative defense.
Yes.
For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court
Affirmative defense is he
through
was
the
18.
legislative
defense.
history makes it clear it's an exception. It's not an affirmative defense.
It's in the statute.
It is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in 3 different places, it tells you in plain language that it does not apply. Not for hunting purposes. It does not apply, period, to 16 and 17-year-olds.
On just a purely presentational basis, Kyle's lawyer is much better.
That
He's
is-
looking at the
and I
court. He's not
provided
hunched
that to the
over.
court, both in
I mean,
the Act and in the Senate bill, Judge, and in the Legislative Reference Bureau information.
Well,
So-
It's insane
I'm
to
going to
suggest
give the
that
instruction
an
as
exception
I've
written into the
stated it.
statute is an affirmative defense.
These are.
If it was an affirmative
these
defense
are
written into the statute, it
educational.
would
They
say
don't get
it is an
a
affirmative
copy, and
defense
they're-
to this crime.
Just so they know what we're talking
Yeah.
about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which you shouldn't assume, but if the motion is denied, then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think
Fact, the defense's hair is nicer.
I don't want to leave them uninstructed on the one hand, and I don't want to misinstruct them on the other. But no matter what it is exceptional from the general language of the statute.
I'm not going to.
No, it's
in
in the language of the
liability
statute.
offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
Unless he has the.
No.
That's the last part of the statute. In
Yes.
Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17.
That's how you read it.
Right, not how we
That's how
read
we
it.
read it.
ooh, nice little burn there.
That's how they, that's how they say it.
Yeah, okay.
So in
all right.
16 and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
It's not
And
what the
that's
statute
completely
says.
ignored,
Not at all.
in Mr. Trofsky's argument.
Okay. I am going to
Grant the motion to dismiss. That'd be funnier.
give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay, and the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an except, or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't I have a general instruction on self-defense?
You listed them specifically for the charges or for the counts.
Did?
That's what I saw.
Boy, it was early this morning. It says.
Judge is writing jury instructions this
Counts
morning.
1 through 5. Oh, no, that's not it. You're right.
Nice. And I like the way he did it, just very respectfully, where he said, I did. He said, that's the way I read it. Instead of saying yes, or something more demanding.
Yeah.
That was smart.
Self-instruction as, same self-defense instruction as count.
Also, nice spot by the defense lawyer, to
Doing their job, at least.
Doing their job.
That's good news.
we'll give credit.
1, 3, and 4.
Very good. I just wanted to make
Yeah,
sure that.
you were correct in your observation.
Well, you tell me when you're ready, Judge.
I think he's cutting and pasting as we speak.
Yep.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count 2? Count 2, I'm sorry, 820, jury instruction 820
Yeah.
is mentioned in there. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph The last sentence says the defendant does not have a privilege of self-defense as to Richie McGinnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language. Yeah. And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee, was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the.
Why doesn't he have a privilege of self-defense?
Because it's reckless endangerment.
Was criminally reckless, and also was a factor for them to consider in determining whether it was done with utter disregard for human life.
But the problem is the self-defense would flow because intent follows the bullet, right?
Should.
So therefore, the privilege of self-defense should flow.
We put a law school test together on this,
Yeah. But the jury instruction suggests that you don't have the privilege of self-defense in a reckless endangerment shooting.
I think if he's in self-defense as it relates to Mr. Rosenbaum,
generally,
I guess strictly speaking, that must be true because if it's reckless, strictly speaking, it's not intentional. So you can't have a reckless self-defense. So I guess that must, strictly speaking, be correct.
Create an unreasonable risk to another.
Although that's confusing as shit.
Let's give a situation where I'm out on the street and somebody confronts me, and there's a family of 4 little children right behind him, and the other person, the other actor, puts me in. I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone. The danger zone is not only the actor with whom I have a perfect self-defense, privilege of self-defense, but also the 4 children who are behind him.
No, this is a bad read on this.
I think this is how I reconciled that reading in my mind was that when the jury decides about the charges involving the 4 children, the jury is to consider whether I was acting in self-defense with respect to the bad actor. That's a consideration in determining whether my conduct was reckless with respect to those children, and also whether it was showed utter disregard for human life. And the jury might reconcile that by saying, well, you should have tried to change positions so that your shot wouldn't have the children in the background.
That is an insane read.
I agree. That's an insane read of self-defense law.
I read 820 to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says.
I don't even understand. That doesn't make sense.
Then,
well, why did they? I'm sorry. Go ahead.
No, so I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by
Kyle,
that
stop
fact,
yawning.
according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then period.
Right.
So
correct.
Why does it say up above that the in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said.
What you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't you're telling
It does
me
necessarily
that
mean,
self-defense
yeah,
not
that's what
only
he's saying. It
the
does
mother,
necessarily
but
mean
also
that.
the children.
Only if, according to 820, only if the conduct against the bad actor was self-defense.
Yeah, right.
That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another.
Yeah, of
Correct.
course it can.
Period.
Right. He's right. This is like pretty basic self-defense theory too, which is confusing me. When the judge finally gets stopped talking, we'll talk about this more because it's weird.
Yeah. Well, we can briefly address what they're trying to reconcile is this conflicting jury instruction that says you cannot have self-defense in a reckless endangerment charge. You don't have the privilege of it, which I think if the charge is standing alone, that makes sense.
Right.
Because if they're recklessly endangered, you're not acting in self-defense, because if you're acting in self-defense, your actions aren't reckless.
Yes, right.
In the scenario where you are acting in self-defense, firing a bullet at someone who is an aggressor, the people around them could, in theory, be endangered. And the self-defense should flow into that reckless endangerment because, again, you're not recklessly endangering person B because you're lawfully shooting person A.
Right.
That doesn't make a lot of sense if you're justified in shooting one person.
I'm a little bit surprised he didn't actually use the phrase "intent follows the bullet" as part of his argument, because this is intent follows the bullet. Right. I have murderous intent with respect to person A. I shoot at person A. I actually hit person B. Person B dies. I'm guilty of murder. Self-intent follows the bullet.
Right.
But it works the other way around. I have a valid self-defense claim.
Instructions committee. On page, well, I don't know if you've got the pages there, but well, I haven't. But near the end, it says.
Yeah, so self-defense works the same way. I have self-defense with respect to person A.
For example, the defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not what you're arguing, I think, becomes a perfect self-defense as to injury to others.
Right.
During
Correct.
the exercise of perfect self-defense.
Correct.
I don't think that's the law.
I think it is.
Maybe it was what we once thought, but I don't think it's the law now. And that the jury, when they approach the McGinnis case, looks at whether
The law changed somewhere along the way?
Just so the chat knows,
even if exercising
jury is not in the courtroom
perfect
right now.
self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, but instead the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the count involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was,
Nate the lawyer has it right.
if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it.
But it's a confusing jury instruction. To
It's
say
a very
you-
confusing jury instruction.
You don't get
Now,
self-defense,
but
but
I am
if you
going
get
to-
if you
I'm
did
gonna
self-defense,
try to-
then the
Yeah,
jury
yeah, yeah.
considers
Put around
self-defense.
those
Yeah.
5th and 7th counts because we don't have an instruction for number 7 and
I'm also going to pick apart the judge's
And,
hypothetical when I have a chance.
number 6 is. I've had lots of statutory issues come up over the years, and this is the naughtiest.
Is it though?
Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me.
Istari,
State?
we'll try and
No.
clear it up in a second.
Okay. Let's get the jury down.
Okay, you want to
Okay.
quickly?
Go ahead.
No, I was going to say you want to hit that hypo.
Yeah, so I wanted to complete my previous thought since I kept getting interrupted by the judge.
Yeah, I get some.
If you have self-defense against person A
At the end
and you
of
fire person A and hit
last
person
night,
B, it's still self-defense because intent follows the bullet. So intent follows the bullet works both ways. So now let's pick apart the judge's hypothetical. In the judge's hypothetical, the way he described it is there is a person who is in fact posing an imminent threat of death or grievous bodily harm to me, right? But also there are 4 children behind him, or family that has 4 children, or whatever, right? So that's the premise. And he says, okay, so I have a right of self-defense against this guy.
Hey,
I have a perfect right of self-defense against this guy. Fine.
and I think
But I might also simultaneously be reckless to the 4 children. Then he goes on, why? Well, maybe I should have moved
Mr.
and
Smith
fought
has,
and shot from a different position.
that,
But wait a second.
at a previous employment where
I have an imminent threat of death or grievous bodily harm. Where do I get the time to move to a different position from?
prior
The entire premise of I have an ongoing or imminent threat, but also I should move to a different position.
before we went on the record as well.
Where's the time?
Any question or observation?
Yeah, it's a weird one. What just happened
you
was
feel
the
the need
audio
to ask
video
her if
guy
that would have any
last
impact on her
night or this
ability to
morning
serve?
passed by a
I don't-
juror. So
You could
Binger
ask
is
you could ask
informing the
me
court
to
of this.
ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have question about the accuracy of the report to me. I think it's a non-issue.
What, they just happen to walk by each other on the street or something?
No, when he was coming in to set up the
to go
camera and audio
What?
equipment
Okay, anything else? And I did get a note.
in the courtroom.
Do you know from whom?
I
this
guess it
came?
must have been yesterday, last night.
Well, I don't know which
And
one.
what did they do? Say good morning or something like that, and we're having a fight over it?
Did you see them put a turn number on there?
I think the
Yeah,
risk
yeah.
is
And
that
then I like what Batman says too. Yeah, maybe I should have moved. Also because, well, we were establishing it from the judge's hypothetical. Like in this hypothetical where I'm on the street, it doesn't make sense. It makes even less sense for Kyle Rittenhouse because, as you point out, he was on the street. It's like, oh, I should have fired from a different position as I was, on my back.
There's another subtle aspect of what happened. The judge read the comment, and it's probably from the same statute, but the comment was over a reckless injury, not reckless endangerment. So in his hypothetical that encompassed the comment from the jury instructions guide, it's talking about recklessly injuring one of the children, which would change the calculus from, well, he shot and put one bullet in the aggressor and the children were endangered because a bullet came their way, versus he shot and struck one of the children. So let's say hypothetically, you use your self-defense claim by firing an automatic burst, right? Burst fire from an automatic weapon, and you fire off 6
Only
or 7
suppress
rounds.
the
or
sound
something.
while I hold it down, or does it click on and off?
What?
Press-
We're confused about microphones now?
And then if I put, and now I'm live again, right? Okay, I've got some nice hand signals here from the respectful hand signals from the court TV crowd.
I got some hand signals. No, that's a bit unfair. That's a bit unfair.
So that
but I do love what Nate was saying earlier, where he's screaming into the void in caps. Go back to read it, or see if I can find it where I can quote him. But he says, from several points ago, he says, "Perfect self-defense cannot be reckless. That's a legal impossibility. If it was reckless, it's not perfect in all caps self-defense because he was reckless." Yes, Nate, we're with you, and I'm enjoying watching you scream into the void as you try to reconcile the word perfect with the word reckless, and like me, have basically your brain stops working because it's a mutual conflict. It's one of those things where you tell the robot, "I am lying. I must be believed, and I am lying." The robot blows up because it can't deal with a logical paradox. Yeah, perfect and reckless have a problem in the same sentence. You are correct, sir. Perfect recklessness. Yes, exactly. That's where we're at. Perfect recklessness, or reckless perfection, or something.
Yeah, the entire that's the interesting thing is Kyle's claim is one of relatively perfect self-defense. No bystanders were struck. The closest that we have is McInnes suggesting he was briefly afraid that he thought he had been hit by a bullet, and we don't know if that was like a piece of concrete or something hitting his leg, or if it was just psychosomatic reaction to hearing gunshots at close proximity. Who knows? He thought he had been struck, but he was not struck in any way. He was not injured. So I'm not sure how we get to the judge's hypothetical.
Okay, well, I guess too, but
it is a but it is a very concerning or confusing jury instruction to say you don't get self-defense, but if you did self-defense, then then the jury can consider it. I think it's covering the idea that you're like, someone in the chat says, or good logic in the chat says, you can't self-defense with a nuclear missile, right? So, okay, yeah. So if you have a howitzer or something and you self-defense someone and it blows through them and into the next county, I guess you're recklessly endangering the people behind the target.
I haven't really considered the self-defense implications of the perfect self-defense, but with a howitzer. So yeah, I haven't. You might have a point there somewhere, but let's, I don't know. I don't know how perfect self-defense works with a howitzer.
I have no idea. This is the issue, and this is why arguing over these jury instructions is really important and getting clarity to the jury, because we're confused by this. We're lawyers. The judge is confused by this. He's not only a lawyer, but a judge.
The fact the judge is confused, or the fact that the judge seems to implicitly acknowledge the wording is difficult to parse, because he just called it like the naughtiest legal issue he's had, and he's going to give this to a jury.
Yeah. With
these instructions.
It bothers me that Binger is by far the tallest Geiga Chad in the room because he's such an effete idiot. He's like a foot taller than everybody else in that frame. Oh man.
Information in this case charges that on
onto the count. Look at this stack of papers the judge is sifting.
25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life.
That's going to be a hard
First-degree
one.
reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death.
Substantial factor,
Second,
back to
the
like the
defendant
Floyd
caused the
discussion,
death
right?
by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant.
Third element, buddy.
You lose your place on the page.
The third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's
now
conduct
literally
showed
marking
utter
it when he reads
disregard
it.
for human
I mean,
life,
that could work.
consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male. And to each of these charges as well.
How is he still unknown at this point,
Guilty.
right?
Reckless endangerment of the first degree as charged in these counts is committed by
That's
one who
like
recklessly
conceptually a little bit
endangers the
weird. It's
safety
like we
of
can't even
another
identify
being
who the purported
circumstances which show
person who was
evidence
acted
of
against
regard
is, for
life.
sure.
Before you may find the defendant guilty
Criminal
of
violation against John
of the first
Doe.
degree as to either of these counts. The state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm.
That's a weird one because
Great bodily harm means injury which creates a substantial risk
not
of
privileged
death,
to
or
self-defense
which
there, but that
causes
guy just kicked him in the
permanent-
face.
serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place, the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to determine intent, which must be found, if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be intent should not be confused with motive. While proof of motive is necessary to a conviction, while proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally under all of the circumstances that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that
he missed.
Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and
Doc, get a cough drop or something,
may have
man.
been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case, which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not.
Intent versus motive will trip some lawyers up, man.
Doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The sixth count charges
what
that
Nate
at
the
the
lawyer
same
said
time and
about
place, the
Gage
defendant
Grosskreutz. He's a
was a
UNICEF
person
now.
under the age of 18 years
No more biceps for him.
and was armed with a dangerous weapon. The seventh count charges that
I didn't think he was going to read that.
at the same time and place, the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts.
The denialist says step 1, buy a howitzer. 2, name it perfect
The
self-defense.
first 5
3,
counts of the
fire in random
information allege not
directions.
only that
4,
the defendant committed the crimes
profit?
which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called
So,
answer it,
air-based guns
then
are
you
not
must
firearms,
be
I
satisfied
guess.
beyond a
Somehow,
reasonable
yeah.
doubt that the defendant committed the crime while using a
or
dangerous
rail
weapon.
guns.
Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and attempted intentional homicide. A separate instruction applies to, I'm sorry, I misstated that. The reckless, the instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count. And that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way.
Such a confusing jury instruction. Terribly,
the law of
terribly
self-defense
conceived.
allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who is in the area of the gunfire.
Doesn't automatically follow
And
through. Come on. Oh my God.
so you have to analyze that separately and determine, well, I'll get further into it. Keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard McGinnis.
Christ.
If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life.
Guarantee no
The burden
juror
is
has
on the
followed
state
this.
to prove beyond a reasonable doubt that the defendant
I'm not sure I'm following it.
in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this
In
case.
fact, I know I'm
The
not.
circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution.
Everybody blaming
Act
the
with
judge for
judgment,
this.
reason, and
Chill out a
prudence.
minute.
The
Like,
defendant is
these
not
are
required
the
to
jury
prove his
instructions from
innocence.
Wisconsin.
The law
The
presumes every
instruction
person
itself
charged
is
with the
bad.
commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving
It's
the
one of the
defendant
better definitions of reasonable doubt I've heard.
every
So
reasonable doubt. We're going to hear the opening statement.